Dear Chief Acosta, my sister got married last year in the USA. Unfortunately, after only a couple of months, she learned that my brother-in-law has a mistress whom he lives with in another state whenever my sister has weeks-long duty of work. My sister is thinking of going back home here in the Philippines because she has been under a lot of stress with what is happening in her marriage. But she also needs to stay in the USA because of her work as a medical frontliner. Can she file a case for concubinage here, assuming she proceeds with her plan of coming back? She and my brother-in-law are still both Filipino citizens. Please advise. Cassy.
Dear letter sender, under the Philippine laws, the crime of concubinage is committed by a married man who keeps a mistress. To be certain, Article 334 of the Revised Penal Code defines the means of committing concubinage and the imposable penalty thereof as follows.
Article 334, Concubinage. Any husband who shall keep a mistress in a conjugal dwelling or shall have sexual intercourse under scandalous circumstances with a woman who is not his wife or shall cohabit with her in any other place shall be punished by prisión correccional in its minimum and medium periods. The concubine shall suffer the penalty of destierro.
In the situation which you have shared with us, you mentioned that your brother-in-law is maintaining a relationship with a concubine. Unfortunately, however, he may not be held criminally liable here in the Philippines under Philippine laws, particularly under Article 334 of the Revised Penal Code, because the commission of the crime transpired in the United States of America and not within the territory of the Philippines. We wish to emphasize that there are three cardinal principles governing our criminal laws, and one of which is the principle of territoriality. Basically, it must be established that the crime was committed or any one of the essential elements should have taken place within our jurisdiction in order for our criminal laws to apply, unless such falls under any of the exceptions. This is pursuant to Article 2 of the Revised Penal Code, which states that, and I quote,
In Article 2, application of its provisions, except as provided in the treaties and laws of preferential application, the provisions of this code shall be enforced not only within the Philippine archipelago, including its atmosphere, its interior waters and maritime zone, but also outside of its jurisdiction against those who 1. Should commit an offense while on a Philippine ship or airship. 2. Should forge or counterfeit any coin or currency note of the Philippine Islands or obligations and securities issued by the government of the Philippine Islands. 3. Should be liable for acts connected with the introduction into these islands of the obligations and securities mentioned in the preceding number. 4. While being public officers or employees, should commit an offense in the exercise of their functions, or 5. Should commit any of the crimes against national security and the law of nations defined in Title 1 of the Book 2 of this Code.
Notwithstanding, it is advisable for your sister to seek legal counseling with a lawyer in the United States of America, particularly in the state where the crime transpired, in order to adequately evaluate her legal concerns consistent with the laws of that state, as well as the possible filing of a criminal complaint there against her husband so that she may obtain justice for the infidelity committed by her spouse. We hope that we were able to answer your queries. Please be reminded that this advice is based solely on the facts you have narrated and our appreciation of the same. Our opinion may vary when other facts are changed or elaborated. Tomorrow, we'll look into another question from viewers and readers of Dear PAO. This is your host, Dr. Persida V. Rueda Acosta, PhD, and the Chief Public Attorney of the Republic of the Philippines. Goodbye for now.